Can the witness confirm that he's still in the oath? Thank you. Advocate Selna.
Thank you, Chair. Chair, we must comment that we are sure that the view is preferable for the commissioners from the podium, and we would like to thank the commissioners for the indulgence and it enabled us to show the presentation, which we think that has gone some way to clarify what are otherwise fairly complex issues, and for that we say thank you. Commissioners, when we parted yesterday, or when we adjourned, Mr. Chrysal had completed his formal part of his testimony. During the course of giving his testimony, an issue arose regarding a meeting of the AAC of the 13th of July 1998, and Mr. Chrysal indicated that he is not aware of a meeting, such a meeting ever being held. As I indicated yesterday, during the course of the hearings, a minute was tracked down by the competent staff of the Commission, specifically of the AAC of the 13th of July. This minute is placed before this Commission through this witness on the basis that Mr. Chrysal, in fact, was a part of that meeting on the 13th. That being the case, we believe he is the appropriate witness to shed light on some of the issues arising therefrom. A copy of this minute has been placed before the commissioners. It is not part of the record yet, as in anticipation numbered pages 212 to 228, and it should follow on the last document in the quotation file, which currently has 2 sets of minutes. The second set of minutes starts at page 187 and ends at page 211. So this minute of the 13th of July of the AAC will follow therefrom. Chair, are you with me? Chair, I'm told, Chair, if I may inquire, has the minute been located and do they follow consecutively?
Thanks a lot. They have been located. Thank you.
Thank you, Chair. I think Mr. Solomon has got some difficulty, if I may just assist him. You have to press.
Thank you, Mr. Chair. We have proposed to insert certain documents for the purposes of re-examination. Some of them are extracts from the defense review, which we have numbered 212 to 216, and then the constitutions of the AAC, AASB, and the AACB, we have numbered from 217 to 229. We had proposed to insert these in Mr. Chrysal's bundle. So I wonder if we shouldn't then suggest that what's been introduced now should follow from 230.
Chair.
I'm sorry, can I make a simple suggestion? The ones that we have, they've already been numbered. We're simply going to put them in here. Can't you start renumbering yours from 229? Because this one goes right up to 228.
Yes, Chair, I'm sure that won't be a problem. My attorney's listening, and perhaps she can just then renumber these pages. Thank you.
Thank you, Chair. We would support that because we think preferably the evidence leaders' documents must all be sequential until the last document, and then documents introduced in re-examination should start thereafter. Otherwise, in time to come, it might become confusing as to which party introduced what document. Thank you, Chair. Mr. Grissel, please refer to the minute of the AAC of the 13th of July 1998, which we say is now numbered 212 to 228. Do you have it before you?
Do.
Can you confirm that according to this minute, you were a part of this meeting by virtue of having been invited, as appears on the first page of this minute?
Chairperson, I do confirm that. Yesterday I could not offhand remember the meeting, but I was indeed a part of the meeting, and it did take place.
And just very briefly, would you describe or would you explain to the Commission what is contained in this minute?
Commissioner, the special AAC meeting of the 13th of July 1998, from perusing the minutes, refreshing my memory, presentations were made to the AAC, and this was a special AAC which was also attended by the Minister of Trade and Industry and senior officials from the Department of Trade and Industry. The presentations were made to the special AAC relating to the progress that had been made on the evaluation of the different projects. A similar presentation that was made to the AASB on the 8th of July, where the consolidated results of each of the projects were presented to the AAC, and also the costed and non-costed option of the lift was presented to the AAC for information purposes. And during this meeting there was also a number of discussions relating to the defence industrial participation associated, or defence industrial participation offers associated with each of the bids that were received.
Thank you, Mr. Grissel. If just to recap from yesterday's evidence, you informed the Commission that notwithstanding what is reflected in the confirmation notes of the SOFCOM work group of the 1st and 2nd July, the so-called non-costed option was not debated or discussed at that SOFCOM meeting. Is that correct?
Not that I could recollect, Chair, no.
And you testified that following that work group session, SOFCOM made a presentation to the ASB on the 8th of July, 1998.
And that is correct, Chair.
I would like to refer you to the minute of the ASB of the 8th of July, 1998, and commissioners, that will be in the quotation file from page 172. We dealt with this minute yesterday, and Mr. Grissel has confirmed that he was a part of this meeting. Now, Mr. Grissel, if you refer to page 177, under overall summary, and in particular paragraphs 30 and 31, could you please read those two paragraphs into the record, and to the extent that you deem necessary, to explain to us what those paragraphs mean?
Thank you, Chair. Paragraph 30 of the minutes of the AASB of the 8th of July, which would be on page 177, reads as follows. The AASB notes the progress and resolves not to make any pronouncement on what was presented. However, the Minister of Defence and the members of the AAC must be advised of the progress. Paragraph 30 reads, arrangements to brief the Minister of Defence on 13th of July, followed by a select cabinet committee, and then in brackets, Deputy President, Minister of Finance, Minister of Trade and Industry, Minister of Defence, close brackets. Briefing on 21st of July are underway.
Are we correct to understand, therefore, that the decision of the ASB on the 8th of July was not to make a recommendation to the AAC at this juncture?
And that is correct, Chair.
Thank you. Could you now refer to the minute of the AAC of the 13th of July, 1998, which is the new document we've just introduced, numbered pages 212 to 228, Commissioners?
Yes, I have it.
Commissioners, have you located the document, AAC meeting of 13th July from page 212? Thank you. These minutes reflect from pages 212 to 218 issues concerning the various bids. Is that so?
That is correct, Chair.
On a reading of these minutes, does it appear that the AAC took any particular decision regarding any of the bids?
Negative, Chair. The AAC did not take any recommendations, and from the minutes it is clear that this was a briefing for information to the AAC.
If you have regard to page 214, under paragraph 9, you will see that that paragraph deals with lead in-fighter trainer, and it provides for two options, costed and non-costed. Paragraph 9, Chair. At numbered page 214. You were a part of this meeting, Mr. Chrysal. You testified that the ASB did not resolve to make any recommendations to the AAC. Could you explain to the Commission how the non-costed option, which you had explained was not part of the evaluation, was put up for consideration and briefing to the AAC?
Chair, the minutes of the meeting of the AAC of the 13th of July reflect that the results of the evaluation as compiled by the SOFCOM and presented to the AASB were all presented to the AAC for information purposes. Similarly, the two options for the lead-in fighter trainer aircraft that were presented to the AASB on the 8th of July were presented to this special AAC meeting as well, indicating the best value scores for each of the bidders in both options, costed as well as non-costed.
At the time of presentation of the non-costed option to the AAC, did the chairman of the ASB or any member of the ASB point out to the AAC that the so-called non-costed option was not part of the deliberations and or progress of the ASB?
It is not clear from the minutes whether it was explicitly indicated that this was not part of the evaluation, but there was a discussion regarding the rationale behind the explanation of the costed and non-costed option.
I accept that it is not clear from the minutes. From your own personal recollection, was such a discussion had?
Chair, from my personal recollection, it was not explicitly indicated that this was not a recommendation by the SOFCOM. It also must be borne in mind that the presentation to the AAC, although presented by the co-chairman of the SOFCOM, was in fact a presentation by the AASB to the AAC.
You testified yesterday that the non-costed option table was prepared by yourself or at the request of the Chief of Acquisition. Is that so?
That is correct, Chair.
At the time you prepared that table, was it your understanding that it was intended to eventually serve before the AAC?
Chair, no. I prepared the tables of the consolidated results of all the different products with the information as presented by the respective teams during the meeting of the SOFCOM of the 1st and 2nd of July. From that, the table for the costed option of the lift was prepared together with all the others. It was at a later stage that I was requested to prepare an alternative table indicating a non-costed option, which would be done by means of excluding the cost from the military value for each of the offers which were received, thus resulting in a best value figure which was different from the best value figure indicated in the costed option.
The Chief of Acquisition at the time, according to your testimony, was the co-chair of SOFCOM. Is that correct?
That is correct, Chair.
And again, according to your presentation over the past 2 days, we know that Mr. Esther Haze of AMSCO was the other co-chair. Is that correct?
That is correct, Chair.
Apologies, Commissioner. Now, when the Chief of Acquisition requested you to prepare a non-costed option, was he doing so in his capacity as Chief of Acquisition, as co-chair of SOFCOM, or any other capacity that you would like to point out?
Chief of Acquisition requested a number of presentations to be prepared for various reasons in his capacity as co-chairman of the SOFCOM. I did not report to Chief of Acquisition in any other capacity, as he was in a different department.
Having prepared the non-costed option and given the Chief of Acquisition a copy thereof, did you draw the other co-chairperson's attention to this table, and particularly Mr. Esther Haze?
Chair, I believe that Mr. Esther Haze was not in the organization at that point. He had left very shortly before that time, had departed from AMSCO. So I did not draw his attention to it, but I was developing a number of different iterations of tables, including more information, etc., for the Chief of Acquisition in his capacity as co-chairman of the SOFCOM. He requested me to prepare another slide, which would be titled an option B, or a non-costed option for the leading fighter trainer aircraft. At the time, it was unclear to me as to what the intention of this was, or whether it would be for information purposes only to indicate certain aspects, or whether it would be for decision-making purposes. So at that point in time, I did not deem it necessary to inform anybody else, because I did not know what the intention was with that non-costed option table.
You state that you did not know what the intention was with that non-costed option. Did the Chief of Acquisition explain to you what the purpose of that was, for that non-costed table?
No, Chair. The Chief of Acquisition hardly ever explained the purpose of these tables. He requested me to make a table with certain information in, which I did and handed it to him.
When did you first learn that that table you had prepared at the behest of the Chief of Acquisition had made its way into the formal structures of the DOD regarding the evaluations of the bidders?
Chair, I attended the presentation that was made to the AASB on the 8th of July, where all the tables were presented to the AASB with all the consolidated results of the evaluations which had been done. It was at that meeting where both the options, costed as well as non-costed option for the lift, was presented to the AASB as two different options. And that was the first time that I became aware that this was now being fed into the formal DOD structure.
At that point, did you draw the AASB's attention to the fact that the table was generated by you and was not generated for purposes of presentation to the committee?
No, Chair, I did not do that. I attended the AASB as an observer, and the Chief of Acquisitions had an explanation as to why he was introducing this non-costed option. I did not draw the attention to the fact that I had done it after the fact.
For the sake of completeness, could you remind us as to what reason the Chief of Acquisition gave for introducing this non-costed option?
Chair, as I indicated briefly yesterday, during the meeting of the 8th of July, where the results of the evaluation was presented, on the lift, the Chief of Acquisition, who was the presenter of the consolidated results to the AASB, presented a slide with the results from the request for information, where all the responses to the request for information for this aircraft was evaluated and plotted in terms of functionality versus cost. So it was a graph indicating the results of each of those evaluations from the request for information, which indicated the measured functionality of each of those aircraft together with the cost. On that graph, it became evident that there were two, as they called it at the time, clusters of results, which would be a lower cost with lower functionality group of aircraft and a group of aircraft which had higher functionality and higher cost. It was on that graph where the functionality threshold was drawn, being 65% functionality, and all aircraft above that 65% functionality would then make its way onto the shortlist for the leading fighter trainers best and final offer solicitation. Above the functionality threshold line were the aircraft which appeared on the RFOs, and all except the Aeromaki MB339 aircraft were in the higher cost, higher functionality cluster. The Aeromaki aircraft was in that group which had a lower cost, but still with a functionality which was above the set threshold. The argument at the AASB was that it would not be correct to compare the results of all of these aircraft on the basis of cost, seeing that they fall into two different clusters of cost, and that an alternative option was being presented where cost was taken out of the equation to then compare them without the cost, and that was the argument.
Thank you. Please refer to the minute of the 13th of July, the AAC meeting, appearing from pages 212. That's the meeting we had been dealing with. In particular, at page 214, towards the bottom of that page, under paragraph 9, are the results of the lead-in fighter trainer, both costed and non-costed options. Do you see that?
Yes, I do.
Overleaf at paragraph 10 is a discussion. Could you read that discussion into the record and then, to the extent possible, unpack what is stated therein for the Commission.
Chair, paragraph 10 of the minutes of the special AAC meeting on page 215 reads as follows: two consolidated summary evaluations, one of a costed military value and one of a non-costed military value, are shown. The need for a non-costed matrix is queried and explained by means of the two clusters of contenders. Chief of the Air Force highlights the limited operational capability of the more expensive cluster compared to that of the cheaper cluster, and the relatively cheaper South African Air Force preference for a training aircraft which will meet the minimum SAF pilot qualification requirements, starting with the Astra and stepping up from there. The failure of the Air Mackie S211 on the grounds of poor performance and poor weapons training is explained. The relatively low IP percentages offered are highlighted. The SAF evaluation of leasing being non-viable was mentioned. The issue of training pilots in other countries was discussed. The SAF do not recommend foreign training of SAF pilots. The potential need to solicit more information, particularly in logistics support and engineering management, is also highlighted. Chair, if I may attempt to unpack, as has been requested. The second sentence relating to the need for a non-costed matrix being queried and explained by means of the two clusters of contenders is the explanation that I tried to give to the Commission just earlier on. That was the graph indicating the results of the request for information evaluations and plotting the results of cost and functionality. During this meeting, the need for this argument was queried, and the need for the non-costed option was queried, and the same presentation or reasoning behind the non-costed option being introduced that was presented to the AASB was again presented to the AAC. The sentence after that, where the Chief of the Air Force highlights the limited operational capability of the more expensive cluster, relates to the argument which we also discussed yesterday, Chair, and that being that the aircraft falling in the higher functionality and higher cost cluster were all aircraft which would have certain capabilities beyond that of a trainer aircraft. So the limited operational capability which is being referred to in the minute refers to those capabilities being operational capabilities over and above that of being a trainer aircraft, which those aircraft would have. The Chief of the Air Force reconfirmed the same argument as I presented to the Commission yesterday, that the limited operational capability that those aircraft have do not form part of the evaluation, and that the Air Force requirements would be met by the Air Mackie aircraft being a trainer aircraft. The argument again is that the aircraft are being evaluated in terms of the role for which the requirement exists. And in this case, the requirement existed for an aircraft to be used as a trainer aircraft, and no additional score would be allocated to aircraft which had capabilities beyond that which was required for a trainer aircraft. Does that suffice?
Thank you very much, Mr. Esterhazy. I do apologize. I apologize, Commissioners, and I apologize to Mr. Grissel. I referred to him as Mr. Esterhazy, and he definitely is not. And I apologize to Mr. Esterhazy as well. Thank you, Mr. Grissel, for that explanation. While we are on that document, the minute of this particular meeting ends at page 216. Is that correct?
That's correct, Chair.
From halfway, page 216, those are minutes of a different meeting.
That is correct, Chair.
Considering what's contained in pages 212 to 216, can you advise what the decision of the AAC was in regard to the evaluations and the bidders?
Chair, as stated previously, this minute was, or this meeting was an information brief to the two ministers and to the AAC. No decision was made at this meeting, and if I may, I would refer the Commission to page 215, and specifically paragraph 13 under discussion. It is stated there under status that the Chairman emphasizes that this is an initial report and that the process must continue. The ministers must be briefed on the IP business plans, after which more guidelines will be given. Further gathering of information, e.g. for the lift, is supported. So this just confirms the fact that this was an information brief to the ministers and that no decisions were taken at this meeting.
So the Commission can accept that as at the 13th of July, the AAC had not made any decision regarding the preferred bidders.
That is correct, ma'am.
I would like to refer you to the next minute then, which is the minute of the AASB of the 16th of July, 1998. Commissioners, that will be from pages 187 to 211 and the quotation file. We previously dealt with this minute, and we intend to touch on it today very briefly. Mr. Chrysel, you are on record having confirmed this minute and the fact that you were a part of.
That is correct.
Thank you. Regarding the decision as to which bidders to recommend, did this particular meeting make...
I'm sorry, which page are you referring to?
It starts from page 187 to 211, Chair. And just to correct myself, Mr. Chrysel was not part of this meeting.
Oh.
He pointed out yesterday.
Okay.
Mr. Chrysel, you have considered this minute before, and you may take another minute to do so. In light of what is reflected in that minute, could you say that the ASB at this particular meeting took a decision regarding recommendation of bidders to the AAC?
Chair, as I was not at the meeting, but from perusing the minutes, there was no clear statement in the minutes that a recommendation would be forwarded to the AAC post this meeting. This was a regular AAC meeting which also discussed other issues beyond the STPPs. The first section of this meeting related to specifically the lift aircraft. There was no further discussion relating to any of the other projects or other equipment types. There was some feedback given to the AASB relating to the questions posed during the previous AASB meeting of the 8th. But there was no resolution that the AASB would then recommend the preferred bidders any further than that.
On the basis of these 3 minutes, these 3 set of minutes, would it be correct for the commissioners to accept that as at the 16th of July 1998, neither the ASB had made a decision regarding the bidders for recommendation, nor had the AAC itself made any decision regarding these bidders?
Chair, from the 2 meetings that I did attend, there was certainly no decision to recommend beyond those forums, and from perusing the minutes of the AASB of the 16th, I could not find any indication that this meeting would recommend that to any further forums. That's correct, ma'am.
Thank you, Mr. Chrysel. Just to retrace our steps and clarify a point I just raised with you, I had asked whether you had shared the non-costed option table with Mr. Esterhazy in his capacity as co-chair of SOFCOM, and you indicated that he had left the employer for AMSCO by then. Is that so?
I believe that he did. I will have to confirm, but I believe that he was not an AMSCO's employee any longer. I must correct that he did, I believe, attend the meeting of the AAC, but whether he was still in AMSCO's employ at that point in time, I cannot recollect.
And in fact, he not only attended the AAC meeting of the 13th of July, he attended the ASB meeting of the 16th of July. And in both minutes, he is noted as representing AMSCO. Is that correct?
That is correct. It is minuted as such. Mr. Esterhuizen confirmed to me earlier on that he was not in the employ of AMSCO any longer, but from the minutes it is evident that it was minuted that he represented AMSCO.
So if he had left the employ of AMSCO by then, the role that he played and the capacity in which he attended this meeting is a matter to be clarified with him.
That is correct.
Thank you, Mr. Grissel. Commissioners, that is the evidence of this witness.
Is there any person who wants to cross-examine Mr. Grissel? Thank you. Nobody's prepared to cross-examine Mr. Grissel. Any re-examination?
Commissioners? Or am I? So, my apologies, Commissioners.
Okay, okay.
I'm Isaac Chue from the State Attorney on behalf of the DTI. Commissioners, we only request the indulgence just for a clarification question, maybe two of them. It's not cross-examination, I must be clear. It's just the clarification of two issues with Mr. Grissel, if the commissioners will allow us. Just clarifications. It's not cross-examination.
Mr. Chue, I'm sure you're aware of our regulations.
Indeed, indeed, Commissioner.
At what stage should one allow people to ask questions saying that it's not cross-examination, but then it's only they're seeking clarification?
We do understand the rules in as far as that is concerned, Commissioners, and we will then maybe request that maybe we take it up with the legal representatives of Mr. Grissel and the relevant evidence leaders. We will leave it at there.
Mr. Chue, I've discussed it with my co-commissioner, and the view seems to be that probably we should allow you to seek clarification, even if it's not cross-examination.
I'm indebted to the commissioners. Thank you so much, Commissioner. Mr. Grissel, only just two issues. And the first issue regards to the project teams which were involved in the evaluation. Can you maybe remember, in as far as your involvement is concerned, I've seen that you have mentioned the names of, for instance, people from the DTI who were on the NIP project side. Do you maybe remember whether all those people mentioned there, they were at all times present during the evaluation?
Chair, I would certainly not be able to answer that question, as the evaluations all happened as individual teams. I was not present at any of the evaluations that were being conducted, so I would not be in a position to indicate whether those people were at all times involved during the evaluation. It must be remembered that these evaluations, there were 11 teams performing evaluations simultaneously, and they did that in silos, separate from each other, so I was not involved at all in any of those, so I cannot comment on that.
Thank you, Mr. Chrysel. And then just one other question. It is common cause that the International Offers negotiation team was the one which negotiated the umbrella agreement and the annexures thereto. Do you maybe know, in as far as your collections can stretch, whether any of the project teams also made inputs on the final draft of the umbrella agreements?
Chair, I cannot give you a definite answer, but I know there was regular interaction by necessity between the members of the IONT, and specifically those representatives on the IONT representing the different domains, where, for example, the then CEO of OMSCOR was heading up the technical and the DIP domain. There was also a representative, I believe, from Department of Finance and from the DTI. There was regular interaction between them and the technical teams, because the technical teams were negotiating the technical supply terms, which would be affected by the quantities, by the available cost. So the interaction between the IONT and those teams did happen at a regular interval to ensure that there would be alignment between the negotiations which were happening in parallel. But whether there was specific negotiations or interaction between the National Industrial Participation teams and their representative on the IONT, I cannot confirm that.
Thank you, Mr. Chrysel. Commissioners, thank you so much. I'm really indebted. Thank you. They were the only two clarification questions. Thanks.
Thank you. Any re-examination?
With your leave, Chair and Commissioner Musi, I would like to address a few issues that I feel will be of assistance to the Commission. Just from a logistic point of view, I'm awaiting my attorney to prepare and have paginated and punched so we can insert them in your files and in the evidence leaders' files, essentially two series of documents. The one is an extract from the defense review, certain sections and passages from the defense review which we consider Mr. Chrysel can be of help to the Commission. And the second is the constitution of the three bodies that I referred to earlier on, which I think Mr. Chrysel can deal with, and it can also be of some assistance to the Commission. It also strikes me, which I don't think my instructing attorney has yet copied, that there is the minute of the steering board meeting which gave rise to the adoption of the constitutions of the three bodies, which I think should also be inserted in the bundle. But so as not to waste time, if I could just continue, and as and when the documents are ready, we'll, with your leave, Chair, and that of Commissioner Musi, hand up at the appropriate time.
Can I make a suggestion? I think I'm going to adjourn for 20 minutes. In the meantime, you can attend to the copying and paginating of the paper, so that once we start, then we have all the documents.
Thank you, Chair. I think that's totally in order.
Then we'll adjourn for 20 minutes. In the meantime, can those who are supposed to put in place the documents in our files do that? Thank you. We'll adjourn.
Yeah, sharp.
check something. I'm adding them, ne? But this A comes after the 234, ne?
Yeah.
It's like this.
Yeah.
So it means there are 5.
All right. So you have it. And both of the
Of the what?
judges, eh?
Yeah, that one and this one.
Okay.
So I think we'll also have to. No, yes, we're going to Kune misunderstanding.
So you
So this phone rectify.
wanted to clarify it with me. But I'm getting off and
Yeah, that's fine.
Don't worry.
Thanks.
Can you give this to the evidence leaders, please?
But did you give them the first page?
Yes, they have the first batch.
requested a number of presentations to be prepared for various reasons in his capacity as co-chairman of the SOFCOM. I did not report to Chief of Acquisition in any other capacity, as he was in a different department.
The non-costed option, and given the Chief of Acquisition a copy thereof, did you draw the other co-chairperson's attention to this table, and particularly Mr. Esterhuizen?
Chair, I believe that Mr. Esterhuizen was not in the organization at that point. He had left very shortly before that time, had departed from Omschool. So I did not draw his attention to it, but I was developing a number of different iterations of tables, including more information, etc., for the Chief of Acquisition in his capacity as co-chairman of the SOFCOM. You requested me to prepare another slide, which would be titled an option B, or a non-costed option for the leading fighter training aircraft. At the time, it was unclear to me as to what the intention of this was, or whether it would be for information purposes only to indicate certain aspects, or whether it would be for decision-making purposes. So at that point in time, I did not deem it necessary to inform anybody else, because I did not know what the intention was with that non-costed option table.
Intention was with that non-costed option. Did the Chief of Acquisition explain to you what the purpose of that was, for that non-costed table?
No, Chair. The Chief of Acquisition hardly ever explained the purpose of these tables. He requested me to make a table with certain information in, which I did, and handed it to him.
Table you had prepared at the behest of
remove from 234A, ne? For E. And then I insert after 240. 240, okay, all right.
All rise.
Okay.
Thank you, Chair and Commissioner Musi, for the indulgence. We have, hopefully by now, placed in the correct sequence the documents that I just wanted to refer to in re-examination. And then, with your leave, if I could commence with the re-examination of Mr. Grissel. Mr. Grissel, I want to just take you through Volume 2 of the 2 volumes that you have submitted. Perhaps, Chair and Commissioner Musi, we should confirm that Mr. Grissel is still under his oath. Thank you, Chair. Mr. Grissel, if we could just get some type of chronology with regard to the various policy documents that were in force before and during the SDPP acquisition. I'll just deal with the first document in File 2, Bundle 2. It's VB 1000. It's at page 32. And would you confirm from the foot of that page that the implementation date of VB 1000 was 20 April 1994?
Yes, Chair, I can confirm that. 20 April 1994. I can confirm that the implementation date of VB 1000 is the 20th of April 1994.
Then, if we look at the same page, the title page, we see that VB 1000, which you've said in your evidence in chief, was really giving effect to joint policy of the DOD and Arms Corps, but it was designed as a general policy for the management of Category 1 material acquisition process. Is that correct?
That is correct, Chair.
And I understand from earlier evidence that Captain Jordan has indicated what Category 1 material acquisitions are.
Yes, I assume that Captain Jordan did, in his testimony, indicate what Category 1 material is. That is material not commercially available normally.
Then the next document I'd like to draw your attention to is at page 91. It's KB 1000. And would you confirm that the implementation date of that Arms Corps policy was 1 May 1995?
Yes, Commissioner, I confirm the implementation date of KB 1000. The Arms Corps policy on acquisition was the 1st of May 1995.
And if we look further to the title page, we see that KB 1000 was dealing in general terms with Arms Corps acquisition policy.
That is correct, Chair.
Then the next document in that bundle, which deals with acquisition policy, is APROC 097 at page 104. And would you confirm that the implementation date of that document was 1 November 1997?
I confirm, Chair. APROC 097, which is the practice for the selection of contractual sources, the implementation date being the 1st of November 1997.
And if we again look at the summary of the document and what its purpose was, it was to establish the practice for the selection of contractors in a multi-source offer. Is that correct?
I confirm, Chair, that is correct.
Would you indicate to the Commission your understanding of a multi-source offer?
Chair, a multi-source offer would be where offers are solicited from more than one prospective bidder, and we would then need to have a method in place to evaluate the offers received from the multiple prospective bidders to eventually arrive at a preferred bidder.
Thank you, Mr. Grissel. Then the last document I want to refer to, which comes the earliest in time, but it's at the back of the file, is KP 021, which is at page 185. And would you confirm the implementation date is 1 June 1993?
Confirmed, Chair. KP 021 is the practice for the request of proposals, quotations, submissions and orders, and the implementation date being the 1st of June 1993.
Thank you, Mr. Grissel. Then, if we go to the other file, which is Grissel 1, there are further documents that have been referred to, and it may be important just to get the chronology right. I'm referring to page 46 and following of Bundle 1, and I'm referring you to paragraph 2 of that document. We see that the origin and date of this DoD policy directive, MOD policy for dealing with the international defense equipment offers in the MOD, that was Planning Directive CLD WPNS/R/302/6/B, dated 2nd July 1997. Do you confirm that?
I confirm, Chair, that this is the DoD policy directive for dealing with international defense equipment offers, origin and date, or the date being the 2nd of July 1997.
And then from paragraph 1 of that document, there's reference to Appendix A, which is described as the policy decision, the process whereby international government-to-government defense equipment offers are dealt with in the Department of Defense and Arms Corps, is to be in accordance with this policy directive, which includes the MOD policy in Appendix A. And we find, would you confirm Appendix A, which runs from page 49 to 52?
I confirm that, Chair. Appendix A runs from page 49 to 52. That's correct.
I'm sorry, can we go back to that document which appears on page 46? I missed the dates. MOD policy for dealing
Chair,
with international defense equipment offers.
Chair, this is policy, the DoD policy directive, MOD policy for dealing with international defense equipment offers in the DoD, and the implementation or the date of origin is the 2nd of July 1997, and that date would appear in paragraph 2 on page 46.
Thank you, Chair. I just also want you to confirm the evidence has been given by Captain Jordan, but just to get the chronology of MODAC 1, 2, and 3, according to Captain Jordan, MODAC 1 was approved by the steering committee on the 2nd February 1995. Can you confirm that?
Chair, I do not have the document before me, but as far as I can recollect, that is the date of implementation or date of MODAC 1.
Thank you, Mr. Grissel. Then, in a similar vein, MODAC 2 was approved on the 26th of February 1995.
I'm sorry. I'm not quite sure what is the purpose of this type of questioning. The witness says that I don't have the documents. He doesn't have the documents in front of him. So
Yes.
basically, they're just telling him to confirm what other people have said. He has got no independent knowledge of what you're saying. I'm not quite sure what purpose will this type of questioning serve.
Yes, Chair, we know the evidence has been led, and Mr. Grissel can just indicate to the Commission whether he agrees with those dates that were furnished by Mr. Captain Jordan. If he's unable to confirm then I agree with you, but if he is able to confirm, and if he has no quibble with Captain Jordan's evidence in that regard, I think it's important just to get the chronology for the purposes of the re-examination.
So if it's on the purpose of putting those questions to him is to prepare ground for re-examination, tell him exactly what the witnesses have said, because we do have those documents. The evidence is already before the Commission.
Thank you, Chair.
Thank you.
Well, Mr. Grissel, the evidence of Captain Jordan has been that MODAC 1, which you have not had a quibble with, was approved on the 10th February 1995, MODAC 2 on the 26th of September 1995, and MODAC 3 on 31 May 1996. Would you accept that evidence?
Without having documents in front of me, I accept that if it is already in front of the Commission, that it should be correct.
Then, the next document I would like to just bring to your attention, Chair, we have inserted an extract from the Defence Review, which we have been inserted as page 229 to page 233 of Grissel Volume 1. It's an extract of Chapter 13, just for the purposes of the Commission. I'll ask Mr. Grissel to confirm that the South African Defence Review was approved by Parliament on April 1998, and I'll hand him the Defence Review, of which these documents are an extract.
Chair, yes, I confirm that the South African Defence Review was approved by Parliament in April 1998.
Now, if we could just look at pages 229 and following, and for the benefit of the Commission, we could go to the chapter dealing with acquisition management policy, paragraph 31. Would you read the second sentence, the 4 role players, and then comment on it to the end of that sentence?
Chair, on page 229, which is an extract from the Defence Review, paragraph 31, the second sentence reads, the 4 role players involved in armaments acquisition are the Minister of Defence, the Secretary for Defence, the Chief of the National Defence Force, and the Chairman of Arms Corps. They are partners, and the decision-making at all levels allows for the viewpoints of the 4 partners. Arms Corps will be the acquisition agency of the DoD. Control bodies in the process allow for participation by nominated members of the partnership.
Now, the policy that is described in Chapter 13, both in paragraph 31 and following, had that policy been, albeit not approved by Parliament, had that policy been applied by the DoD prior to this date?
I can confirm, yes, Chair, in respect of the structures which are contemplated in the Defence Review being DoD structures resorting under the Secretariat for Defence. Those were also the structures that were contemplated in the MODAC 1 report, and specifically being the AACB, which is the Armaments Acquisition Control Board, the AASB, the Armaments Acquisition Steering Board, and the AAC being the Armaments Acquisition Council.
Thank you. Mr. Chrysal, then paragraph 32, would you read the first sentence of that under the heading, the role of the MOD and the DoD HQ?
Paragraph 32 reads, the ultimate political authority and responsibility for the acquisition function rests with the Minister of Defence.
Then if you could go to paragraph 34 and read the first 3 sentences thereof.
The first 3 sentences of paragraph 34 reads, the Secretary for Defence is responsible for ensuring that all acquisition activities are executed within national objectives, policies and constraints. The Secretary is furthermore primarily responsible for high-level programming and budgeting and in-year control and auditing of defence expenditure, and also for interdepartmental and political and industrial coordination. The Secretary is the accounting officer of the DoD.
Perhaps you could just complete the last sentence. I'm sorry.
The last sentence would then be, the Secretary will perform such duties and functions as may be necessary for civil control of the defence acquisition function and to enhance parliamentary and ministerial control over SANDF acquisition programs.
Then paragraph 35, if you would just deal with the DAPD and the post of Chief of Acquisition and how that chain of command operated.
Chair, paragraph 35 reads, the Departmental Acquisition and Procurement Division, in brackets DAPD, consists of an HQ division responsible for specialist acquisition/procurement to ensure the acquisition of equipment and services on behalf of the DoD. The Chief of DAPD and his support staff are responsible for directing and coordinating all acquisition and procurement activities between the arms of service and Arms Corps. DAPD serves as a single nodal point between DoD and Arms Corps. Chief of DAPD is the process leader for acquisition and procurement of Category 1 and Category 2 items within the DoD. The Chief of Acquisition is also the Chief Policy Advisor to the head of the DoD on acquisition matters and reports to the Secretary for Defence.
And then paragraph 36.
Paragraph 36 reads, Arms Corps is the acquisition agency of the DoD, responsible for professional program management and the drafting of tender documentation for the contracting of industry on behalf of DAPD during the execution of armament acquisition programs. This is in order to ensure the technical, financial and legal integrity in contract management is in accordance with DAPD requirements. The DoD and Arms Corps will jointly oversee industrial development of the industry in order to support DoD acquisition programs.
Now, this civil oversight of acquisitions and procurement, you say, had been implemented prior to the date of approval by Parliament of this defence review. Can you just indicate to the Commission, for example, what role the Secretary of Defence played and the Chief of Acquisition in this exercising of civil control?
Chair, the DAPD acted as an intermediary between the armed forces, the arms of service, and Arms Corps. And as is stated in the document and in the paragraphs which I just read, they act as nodal point. What that in effect means is that they are the point of contact for Arms Corps, and they are the channel through which all requirements from the respective arms of service would be channeled to Arms Corps for acquisition or procurement at that stage. Within the Secretariat for Defence, where the DAPD resided, the budget is also held. So all acquisition activities were coordinated within the DAPD environment. Once the required approvals had been obtained, the financial authorities would be issued from the budget which was controlled by the DAPD and by the Secretariat for Defence. They then authorized the financial authorities, which would allow Arms Corps to continue with contracting of industry to meet the specific requirements that existed.
Thank you, Mr. Grissel. From an Arms Corps point of view, how was the role of the Chief of Acquisition viewed in the sense of the chain of command and the authority that that office held?
Chair, if I understand the question correctly, the Chief of Acquisition represented the requirements stater. In other words, they would be the interface to Arms Corps. Requirements that needed to be executed by Arms Corps would be channeled through the office of the Chief of Acquisition. Would that suffice?
Yes, that suffices, Mr. Grissel. We know that in your earlier evidence you indicated that the non-costed option that was prepared by yourself was on the instruction of the Chief of Acquisition at the time. Is that correct?
That is correct, Chair.
Then if we could just move on to page 231. We don't need to read it out, but in paragraph 42 there is reference to the approval structure for project submissions, and it consists of 3 levels. Perhaps you can just look at that yourself and just indicate to the Commission what was being dealt with in paragraph 42.
Chair, in essence, paragraph 42 deals with the approval structures for the milestone documentation. The milestone documentation, which was indicated previously in my presentation, are those milestone documents at level 6 of the acquisition process. And I believe that in Captain Jordaan's testimony, he also indicated the approval levels for the respective milestones. Those milestones being the milestones which start with the staff target, moving through the staff requirement, project study report, and so forth. The paragraph indicates the 3 main structures or approval structures for the respective milestone documents, of which the lowest would be the AACB, the Armaments Acquisition Control Board, chaired by the Chief of Acquisition at the time. The AASB being the Armaments Acquisition Steering Board, chaired by the Secretary for Defence, and the highest approval authority would be the AAC, the Armaments Acquisition Council, chaired by the Minister of Defence. depending on the milestone document and whether it's a cardinal or non-cardinal program, those milestone documents could either be approved at the level of the AACB or at the AASB on recommendation from the AACB, or in the case of cardinal programs, for example, the staff target and acquisition plan would be approved by the AAC on recommendation of the AASB.
The last sentence of that paragraph, would you just read that out and then comment on it?
The last sentence of paragraph 42 reads, the present constitutions of the above forums will have to change to reflect the new participants of the newly structured MOD and DOD HQ.
Was that done to your knowledge?
Yes, Chair. The constitutions of those bodies were amended to reflect the structures eventually. And this is with reference to the DAPD, which now formed part of the process, with the Chief of Acquisition being the head of DAPD and also being the chairman of the AACB. The constitutions of those bodies had to be changed to reflect the structures as contemplated in the MODAC 1 and subsequently also in the Defence Review.
If we could go to page 240A, which comes after page 240 of the bundle, we have minutes of an AASB meeting on the 21st of, seems, November 1996, and over the page at 240C, we have a document signed by the then Minister of Defence. It's dated March 1997, and it refers to various appendices: the Armament Acquisition Council Constitution and Rules, the Armament Acquisition Steering Board Constitution and Rules, and the Armament Acquisition Control Board Constitution and Rules. And then finally, D, guidelines against which the AASB assess armament and technology acquisition product. We've referred to the Armaments Acquisition Control Council as AAC, and the Armament Acquisition Steering Board as AASB, and the Armament Acquisition Control Board as the AACB. Is that correct?
That is correct, Chair.
If we go to paragraph 3, would you just indicate when the establishment of these forums were approved by the Minister of Defence?
Chair, the establishment of the management forums was approved by the Minister of Defence on the 26th of September 1995.
Then, if we move on and just look at 2.41 or 241, there's the, and going across to 242, we have the constitution of the AACB. Is that correct?
That is correct, Chair.
Would you just indicate what is contained in paragraph 2A thereof?
Chair, paragraph 2A of page 242 reads, civil control and oversight is executed by the Secretary for Defence, who is responsible for ensuring that all acquisition is executed in accordance with national objectives, policies and constraints.
Then,
Apologies, Advocate Solomons. Chair, just for clarity, the document we've just been referred to at page 242, I wanted to find out if page 241 is a part thereof. And the reason for my question is, if it is, the draft AACB constitution, as presented, is dated the 11th of February 2000, and this AACB document is effective almost 2 years beyond the period the witness and I discussed. And in that light, I would like to appreciate its relevance.
perhaps, Mr. Chrysal, you can just look at page 240D, paragraph 6A and B. Would you just indicate to the Commission when these, the commencement of these bodies occurred?
Chair, page 240D, which is a part of the Armament Acquisition Management System implementation instructions. Paragraph 6A indicates date of commencement 1 April 1997.
And then paragraph B?
Paragraph B reads date of revision 1 April 1998.
And then if you could just go to the document that my learned friend, Ms. Seller, referred you to. It's, Commission, it's page 403. It was handed up. It's an extract from Captain Jordaan's bundle. It's not, hasn't been placed in your bundle. I don't know if you still have it, Mr. Chrysal, and I'm not sure if the Commission still has it, but it was dealt with yesterday.
I'm sorry, which document are you referring to now?
Mr. Chair, it's headed the MODAC Investigation of Technology and Armament Acquisition in the Department of Defense, a document dated 8 August 1996, and it starts at page 403. It was dealt with yesterday in Mr. Chrysal's evidence in chief. It was handed to us by the evidence leaders and referred to and handed to yourself, Chair, and Commissioner Musi.
Thank you. I do have the document. Thank you.
Thank you, Chair. I'm indebted to you. That document was put to you by the evidence leader, Ms. Seller, dated, if you look at 404, 8th August 1996, and it contained the constitution of the AAC. That's at page 440, the AASB at 42, and then the AACB at 444. Is that correct?
That is correct, Chair.
Perhaps if Ms. Seller is more comfortable dealing with this document rather than the document that we've introduced, because there seems to be some concern about its adoption in 2000, can you confirm when, to your knowledge, these bodies were first established and constituted?
Chair, the bodies referred to in the document, being the AACB, AASB, and AAC, I would not be able to give the Commission an exact date for the first meetings of any of these bodies, but as far as my recollection goes, it was circa end 1996, beginning 1997.
Just to put the issue beyond doubt, at the time when the SDPPs were being dealt with, were these bodies in existence and operating?
That is correct, Chair, and it is also born from the fact that we have minutes of meetings of these specific bodies during the period of the STPPs.
I'm going to refer you to one of the minutes of the meetings that were referred to of the AASB, where it refers to amending or adopting parts of the Constitution. But I don't think for the purposes of this re-examination one needs to get too bogged down in exactly when the constitutions were amended or implemented. But for present purposes, just go to page 440. If we look at the AAC, would you just read out under role what its role was?
Chair, on page 440, relating to the constitution of the Armament Acquisition Council, the AAC, the role of the Armament Acquisition Council is to act as the highest joint level, in brackets level 1, management group on armaments acquisition. This AAC ensures that armaments acquisition is carried out in terms of policies and procedures and oversees the lower level activities.
We see that the chairperson was the Minister of Defence. It seems to have been, with not counting the secretary, it was initially established as a 5-member body under the chairmanship or chairpersonship of the Minister of Defence, and it had Arms Corps Managing Director as a member. Was this essentially a MOD functionary and body?
Chair, I would assume that, seeing that the Minister of Defence is the chairman, that this would be a Ministry of Defence body.
If we go over the page, the secretary was to be supplied by the Secretary of Defence. Do you see that?
That is correct, Chair.
And then under the functions, you've got a heading chairmanship in the absence of the Minister of Defence. In the absence of the Minister of Defence, it was the Deputy Minister who would act as the chairperson. Is that correct?
That is correct, Chair.
Then over the page at 442 under authority, would you just read that out? It's the third paragraph.
Chair, on page 442, the paragraph relating to authority reads, the Minister of Defence has the final authority on all acquisition matters and has the right to refer decision on acquisition programs to cabinet level.
Thank you, Mr. Grissel. Then if we could go to the constitution of the AASB, would you just read out what the role of the AASB is for the benefit of the Commission?
Chair, on page 442, under the heading Constitution, Armament Acquisition Steering Board, AASB, the role is defined as the role of the Armaments Acquisition Steering Board, in brackets AASB, is to act as a lower joint level, in brackets level 2, management forum, in brackets external to the arms of service. On armaments acquisition, the AASB ensures that armaments acquisition is carried out in terms of policies and procedures and oversight the lower level activities.
Now, if my arithmetic is correct, if we go through the composition, at that point in time, there were 8 members of that committee. Arms Corps was entitled to be represented by 3 out of the 8. And who was the chairperson of that committee? Under whose auspices did that committee operate?
Chair, the chairperson was the Secretary for Defence.
Then if we look at the chairmanship at page 443, about the 4th last paragraph, in the absence of the Secretary of Defence, who was to be the Chairman?
Chair, in the absence of the Secretary of Defence, the DDG, which is the Deputy Director General, Defence Policy, Programme and Budget, will act as chairperson.
Thank you, Mr. Chrysal. Then if we could just move on to 444, if you're dealing with the constitution of the AACB, would you just read out what the role of that body was?
Chair, on page 444, the role of the Armaments Acquisition Control Board reads, the role of the Armaments Acquisition Control Board, in brackets AACB, is to control the flow of acquisition submissions to level 2 and 1. The AACB review and approve programs and approve program amendments on all programs within the prescribed delegation structure indicated in figure 1.
Then if my arithmetic is correct, at that point in time, it was going to be a 10-man body, of which Arms Corps were entitled to appoint two individuals. Who was the chairperson of that body?
Chair, the chairperson was Chief of Staff Logistics.
And by whom is the Chief of Staff Logistics employed?
Chief of Staff Logistics was employed by the Department of Defence, by SANDF.
And then on page 445, the chairmanship, in the absence of the Chief of Staff Logistics, would you indicate to the Commission who would be appointed?
Chair, the document states, in the absence of the Chief of Staff Logistics, he will appoint a chairperson.
Thank you. Now, I want to just return to the Defence Review document that you were reading from, because you had dealt with the establishment of these three bodies, the AAC, etc. Would you just go to page 233 and read paragraph 71 under the heading Tender Adjudication Value Analysis? 233, mine's a bit cut off on the right-hand side, but it's a document before page 234.
Chair, page 233, paragraph 71 reads, all tender adjudication for armaments will be based on a value analysis methodology and procedures. This value analysis methodology and procedures will be formulated jointly by the members of the DoD, in brackets DoD Acquisition Division, including Arms Corps and organized industry. The value analysis system per project must be approved and supported by the Secretary for Defence, DAPD. The value analysis system should not be used to exclude previously disadvantaged contractors and should not limit national strategic considerations which can override technical performance parameters. This value analysis system must be above reproach and should not be a subjective analysis.
Now, you can keep that one, darling. How did you understand this to reconcile with Arms Corps' policy in relation to APROC 097?
Chair, Arms Corps policy, which was valid at the time, indicated that Arms Corps would be responsible for the generation of value systems, that Arms Corps would be responsible for the signing off of evaluation reports, and that it allows for participation on the evaluation teams of members of the DAPD. So at that time, although the Defence Review indicated that the responsibility for The approval of the value systems resides with the Secretary for Defence. The Arms Corps policies and practices still provided for Arms Corps to be responsible for that.
In that sense, was there a certain area of tension between the two spheres of authority?
Yes, Chair, there was indeed some tension with regards to who would be responsible for what during the execution of this process. That is correct.
Then the document that we referred to earlier on, I'd like to return to, which is the Policy Directive 4 of 147. Also, it's at page 46. It's also described as this long reference number CLDWPN. The reason I'm focusing on that is it becomes important when we look at the constitution of the SOFCOM and some of the problems that were raised by the Chair and Commissioner Musi in regard to SOFCOM. But if we could just return to that document, and if I could take you to page 49, the heading of the document is MOD Policy for Dealing with International Defence Equipment Office in the MOD.
I'm sorry to say, I was still trying to get hold of the documents. Can you tell us where that document is to be found? Even before you start reading it, maybe let's first get hold of the document.
Sorry, Chair, I had incorrectly assumed you were with me. We're in volume 1, Crystal 1, and page 49. Are we on the same page, Chair? Apologies. Let's just look then again. The document is headed MOD Policy for Dealing with International Defence Equipment Office in the MOD. Is that correct?
That is correct, Chair.
Would you read the first 3 paragraphs of that document?
Chair, the first 2 paragraphs under the heading Introduction read, several international defence equipment offers have been presented to the MOD and others have been proposed. These international defence equipment offers fall outside the scope of existing acquisition policy, and specific policy for such international defence equipment offers has to be established. The 3rd paragraph falls under the heading Aim, and it reads, to provide MOD policy guidelines and management procedures for dealing with foreign-initiated international government-to-government defence equipment offers relating to armaments acquisition for the SANDF that are to be integrated with an interdepartmental coordinating and decision-making structure.
Now, if we just pause for a moment, we see that it's referring to the International Defence Equipment Office. I take it that was a reference to the SDPPs at the time.
I would assume so, Chair.
And it's indicated that they fall outside of the scope of existing acquisition policy, and specific policy had to be established for these acquisitions. Is it correct?
My understanding of the document is that that is a correct statement.
Now, in your experience as an employee of Arms Corps and then latterly as acting general manager of acquisitions within Arms Corps, had you ever prior to the SDPPs been involved in a package acquisition such as this? And post that acquisition, have you ever been involved in something similar thereafter?
Negative, Chair. Prior to the STPPs, as we know them, and post, there has been no similar activity being executed by Arms Corps or the Department of Defence.
Then if you go to paragraph 4, would you just read that out under the heading delineation of MOD mandate?
Chair, paragraph 4 reads, this policy only addresses the defence equipment of a facet of foreign-initiated international government-to-government coordination proposals. The structure of these proposals dictate the scope of interdepartmental involvement. Non-government supported single product proposals are not addressed in this policy.
Is one correct then in saying that this policy was designed for that specific purpose, the time it was the SDPPs, didn't affect non-governmental supported single product, non-package acquisitions? It was a policy created for the specific purpose that one was dealing with in regard to the SDPPs.
Chair, my understanding of this policy is that is a correct statement, that this policy only related to the Special Defence Package Program, and as I indicated during my submission, there were several other programs being executed concurrently with the SDPPs, which followed the normal policies and processes and which were not affected by this MOD policy.
Then, Chair, I know I'm encroaching upon your time, but I just one, perhaps two questions, and then I would suggest we take the lunch adjournment. But I see this document is dated August 1997, and paragraph 6A refers to approval by the AAC. Just to put any doubt about whether these bodies had been established in relation to the objection raised by my learned friend, Marcelo, can you confirm then that the AEC, at least at this time, was in force?
That is correct. I can confirm that, Chair.
Chair, I'm in your hands. Would this be a convenient time to take the adjournment?
Before I answer a question, how long do you think you're still going to be with him? I'm not pushing you. I just want to determine whether should we take the adjournment now or should we go on for another 20 minutes if you're likely to finish in 20 minutes and take the adjournment only at that time.
Chair, I would guess between 45 minutes to an hour still.
In that case, let's take our adjournment now. Thank you.
Thank you, Chair.